If your game looks a little too much like Pokemon, can Nintendo actually sue you? That's the big question in the ongoing battle between Nintendo and the creators of Palworld that's been a hot topic among the gaming community. This case isn't just about look-alike creatures, it's about something even bigger: how far game patents really go. I'm Kurt Lockhart, a patent attorney, and today we're diving into Nintendo's patent fight with Pocket Pair and why recent developments in Japan and the US might completely change the landscape for gaming intellectual property. When Palworld launched, fans immediately noticed some uncanny similarities to Pokemon, from creature designs to game mechanics. But legally, similarity doesn't automatically mean infringement. Nintendo, however, like all massive companies, has always been very protective of its intellectual property. So when Pocket Pair's success exploded, it wasn't long before Nintendo began taking a closer look at its patents and possible infringements. What makes this case especially interesting is that Nintendo isn't just relying on copyright or trademarks. They've been leaning on patent protection for their game mechanics. And as we've just learned, some of those patents are now under heavy scrutiny, not just by fans and IP lawyers, but by the Japan Patent Office and even the US Patent and Trademark Office itself. So let's start in Japan. On October 22nd, a patent examiner from the Japan Patent Office issued what's called an office action. Basically, it's an official response rejecting the claims of Nintendo's patent application. The examiner said Nintendo's invention lacked an inventive step. That means someone with ordinary knowledge in game design could have created the same concept using information already available publicly before Nintendo filed their patent application. In other words, it wasn't original enough to be patented. The examiner cited multiple earlier games as prior art, including Monster Hunter 4, Craftopia, which ironically is made by Pocket Pair, Ark Survival Evolved, and Kantai Collection, and even Pokémon Go. All these games already showed similar techniques or mechanics that Nintendo's application was trying to claim as a new invention. Now, Nintendo has a choice. They can either abandon this patent application or try to modify it and convince the patent office that their version is still unique. This is a critical moment because if Nintendo can't defend the novelty of its claims, that weakens their legal standing not just in Japan, but potentially in other regions as well, including the United States. Just a few days later, things escalated even further in the US. On November 3rd, the USPTO director, John Squires, personally ordered a re-examination of one of Nintendo's US patents. A patent office-initiated re-examination is actually quite rare. Most re-examinations are triggered by a third-party submission, and usually it's a defense to a claim of infringement. So the fact that the patent office themselves took the initiative here strongly indicates that Nintendo's original patent claims might have been too far-reaching. The Nintendo patent up for re-examination describes a specific game mechanic: the player summoning a sub-character, think Pokemon-style battle, and the game automatically switches between manual mode and automatic mode depending on whether an enemy is present. It sounded innovative when first filed, but here's where it gets tricky. After the director's review, prior art was found that may have already shown this concept years ago. The order indicates that one prior patent from Konami in 2002 and another from Nintendo itself in 2019 already described similar ideas of switching between manual and automatic control modes. That means the supposed unique invention might not have been unique after all. So now the patent office is asking, should this patent have ever been granted in the first place? This re-examination doesn't automatically invalidate the patent, however. It does put Nintendo on notice that they will have to further justify their patent claims to prove there is a valid invention. So let's take a look at the actual re-examination order. So here's what the re-examination order actually says. The US Patent and Trademark Office found what's called a substantially new question of patentability. So you have the order here. It's a director-initiated order for ex parte re-examination. If we scroll down here, it says have determined that substantially new questions of patentability have arisen. And so basically, the USPTO is saying we have good reason to believe the patent might not have been valid when it was granted. And so the order specifically calls out independent claims, claims 1, 13, 25, and 26. Those are the broadest and most important claims in a patent. So here it says to claims 1, 13, 25, and 26 of this Nintendo patent. And so here you've got these two prior art references. This is the Konami patent, and then you've got the Nintendo patent here. And it's later down here, it discusses them a little bit as far as what they teach in relation to this Nintendo patent. And then talks about this substantially new question of patentability. So the independent claims are the foundation of a patent. If the independent claims are invalidated, then the claims that depend them are too by definition. But it's important to note that that doesn't automatically kill Nintendo's patent. I've seen a lot of comments saying things like, well, Nintendo patented summoning characters, but that's been around forever. But that's only part of the story. Every patent has a hierarchy of claims. The independent claims are the big picture. They define the broad idea. Then you have dependent claims, which are more detailed things like sub-character follows the player, or the sub-character can capture the enemy after battle. And those added details are called limitations. They narrow the scope of the invention and make it more distinct from what came before. So in Nintendo's case, if we take a look at their patent, this is the patent that's up for re-examination. If you scroll down to the very bottom, that's where you find the claim section. So all the way at the end, you've got these numbers right here. And so you start with what is claimed is, and then number 1, so that's claim number 1. So you've got claim number 1, 13, 25, and 26 are the independent claims. And so you'll notice that, for example, claim 2 says the storage medium according to claim 1. And so it depends on claim 1. And then you've got claim 3 according to claim 2. And so you've got this dependent claim depends on claim 2, which depends on claim 1, right? And so each of these other claims depend on another independent claim. So the reason the re-examination is only focused on these independent claims is because all the other claims will fail if those claims fail. But if you look at the claims, you've got a bunch of language here that basically creates what are called elements or limitations to a claim. And so, for example, you've got performing control of moving a player character on a field in a virtual space. And so that's a limitation of the claim. And it has to be based on a movement operation input. And then after that, you have performing control of causing a sub-character to appear on the field based on a first operation input. So that's another limitation. And then it talks about when an enemy character is placed at a location and there's a sub-character that's caused to appear. Talks about controlling a battle between the sub-character and the enemy character in a first mode. And so there's a first mode that looks to be a manual battle mode. And then it goes on to say that there's a second mode, which is a automatic battle. And so when you have these claim limitations, it's more than just summoning characters, which may have been done for a long time. You've got these limitations that add further elements to the claims that make it so that you've got to have each and every one of those elements in the prior art, right? And so the prior art has to either teach that directly, or the combination of the prior art has to teach each and every claim limitation. In Nintendo's case, the broad claims cover switching between manual and automatic battle modes. But some of the dependent claims include extra mechanics, how that switch happens, what triggers it, or what happens after the battle. So those are the nuances that often make or break patentability. They show why the patent examiner originally decided the idea was different enough to grant, and they're exactly what Nintendo might rely on now to defend it. So what can Nintendo actually do? During re-examination, they're allowed to amend their claims. Essentially, they can pull in language from one or more of those dependent claims to make the independent claim narrower. It's like tightening the focus of the invention. They lose some breadth, but they may gain survivability. So for example, if the prior Konami game already showed a basic summoning mechanic, Nintendo might add a dependent limitation like the sub-character automatically switches battle modes and can capture the enemy after combat. That combination could distinguish it enough to survive the prior art. Of course, it's not guaranteed to work. The USPTO still has to decide whether that narrower version is truly new. But it's an important reminder, re-examination doesn't automatically end the patent. It gives the patent owner an opportunity to reshape the claims into something defensible. So before anybody declares the patent dead, remember, Nintendo still has legal room to maneuver. And the way they amend these claims could set precedent for how game mechanics are protected going forward. This isn't just about Nintendo and Palworld anymore. It's about how far game companies can use patents to control mechanics and gameplay experiences. For creators and game developers, this is a wake-up call. It shows that even if a big company holds a patent, that doesn't always mean it's bulletproof. Prior art, which is anything that's already been done before, can completely change the outcome of a case. That's why when you're developing something new, a mechanic, a system, or even an algorithm, it's so important to do an IP landscape search before filing or launching. You need to know what's already out there. But even if you understand the IP landscape, the big companies will still try to push the boundaries on what is permissible. They always have and they always will, because that's what allows them to become big in the first place and to stay relevant. So for startups, indie studios, and inventors watching this, here's a few takeaways. Don't rely on ideas alone. Protect the unique implementation, not the general concept. And check for prior art before filing or building. See what's already been patented or published. Stay flexible. If your patent is questioned, you can amend the claims or reframe your protection strategy. Build a distinct brand identity, especially in creative industries. Trademarks and originality often protect more effectively than broad patent claims. And most importantly, don't be afraid to get professional advice early. It's often easier to secure solid IP protection before problems arise than to defend weak claims later. As of now, both the Japanese and US reviews are still ongoing, and Nintendo hasn't made an official statement on whether they'll amend or withdraw the challenged patents. If I were to guess, I think it's likely that Nintendo is going to try to amend the claims for their patent that's under re-examination to try to introduce further limitations that would allow the claims to stand. So this story is far from over. We'll be keeping a close eye on what happens next, especially when the Japan and US patent offices make their final decisions. That could redefine how innovation is measured in gaming IP. So if you found this breakdown helpful, hit subscribe and turn on the notifications, because we'll be doing a part 2 once the next update comes out. Until then, I'm patent attorney Kurt Lockhart, helping creators, founders, and innovators protect what they've built.